lady. Hey, I got a lady. Hey, name is the upper echelon, she a debater. Baby, she can give it to you straight, no chaser. She got the smarts. She got the heart. She got the confidence. Baby, she the upper echelon. You know you intimidated. Stupid can't play with smart. She got the smart. She got the heart. She got the confidence. Baby, she the upper echelon. You know you intimidated. Stupid can't play with smart. Hey, I got a lady. Hey, I got a lady. Hey, name is the upper echelon, she a debater. Baby, she can give it to you straight, no chaser. She got the smarts. She got the heart. She got the confidence. Baby, she the upper echelon. You know you intimidated. Stupid can't play with smart. She got the smart. She got the heart. She got the confidence. Baby, she the upper echelon. You know you intimidated. Stupid can't play with smart. Hey, I got a lady. Hey, I got a lady. Hey, name is the upper echelon, she a debater. Baby, she can give it to you straight, no chaser. She got the smarts. She got the heart. She got the confidence. Baby, she the upper echelon. You know you intimidated. Stupid can't play with smart. She got the smart. She got the heart. She got the confidence. Baby, she the upper echelon. You know you intimidated. Stupid can't play with smart.
Welcome back to the Upper Echelon Podcast, of course, where we keep it real and we keep it jiggy over here. Because why y'all? I want to know if y'all know why. Because we ain't never, ever scared. Hit that like button on your way in. Make sure that if you are watching me, that you are subscribed to this channel. Hit the notification bell, please, so that you can be notified of anytime I go live in the future or anytime that I post content in the future. Welcome in, you guys. Welcome in. It is so good to see y'all. We had so much fun yesterday. Today is going to be a little bit more serious. Well, we are going to be reading over documentation and this paperwork regarding the state of Illinois versus Quadasia M. Johnson. We're going to get into the black and white, y'all. One thing that we're going to go ahead and read over, of course, would be the case summary. So get yourselves together, get your chips, your popcorn, your juice, your wine, your water, whatever it is that you indulge in, and sit down and relax, and let's carefully go over this paperwork. I want to give a big shout out. I don't know if she wants me to say her name, so I'm not going to do that. But I do want to acknowledge my source. Thank you so much for sending me this paperwork. It's teamwork, make the dream work, baby. Thank you to everyone who has already sent in a super chat or a super sticker to me to assist me in reaching my goal tonight of 10 super chat or super stickers to donate to my channel. I appreciate y'all for appreciating me. Thank you so much, sweet queen. Hey to all my mods. Let me give a shout out to my people that are in the room already. Let's get into it, y'all. I'm gonna do my shout outs, and then we're gonna go ahead and get into the meat of this whole thing. Okay, hold on, y'all. Okay, let's see who's in the room. Welcome in, Bam Bam. Welcome in, Jackie. Welcome in, Stephanie Landry, T. Mill, Charlene Banks, Nina Edwards, Roz. What's going on, Roz? Hello, fixing my crown. I know that's right. Hey, Rewa. Hey, Love Cat. Free, what's going on? Hey, you changed me. Common Collective, what's going on? Scorpio Stings, Queen Unique, welcome in, boo. Nancy Davis. Hey, sweet queen. Kim Friend. What's going on, Malish? Hey, TLC. Let's see. I don't want to repeat the same name twice. Hey, Purple Paradox. K Monet, Lisa Smith, Coach, Me Us, So Pretty Germ. I am that somebody. Boo Love, welcome in. Thank you so much for that super sticker. I appreciate you, Coach. Free Thinking, welcome in. CSBSN, welcome in. Katrina, welcome in. Katrina says, hey, upper new subby, love your content. Thank you so much. Nina Edwards said, we the people will be Romeca's voice. Justice for Romeca. I know that's right. Welcome in, Nikki Will, Becca Cry. Let's see. Let's see. Thank you so much, Common Collective, for that super chat. I appreciate you. Yes, let's help Upper reach her goal tonight. I really appreciate it. We're gonna put in some work tonight, baby. Too Real, welcome in. Zoe Ryder, Nay Graham, Free Thinking. Shout out to Free Thinking for that super chat. I appreciate you. Welcome in. Tonya Golden, welcome in. I think I said, I'm not sure, but hey, Lisa Mitchell, Stephanie Maxwell, T Nice, Miss HST, Jay Parker, Blessed Highly, Miss T, Trey Bay. What's going on, Chandrika? Nisham, Rena, Ruby Dixon, Sabi. What's going on, Miss Linda? Let's put it on the flow, baby. Pushing Peace. What's going on, Cassandra? Isn't she lovely? Buttercup, Doris, Block Gina. What's going on? Buttercup. Thank you so much, Common Collective. Common Collective gifted 5 memberships to Miss T, Purple Paradox, Too Real, Nay Graham, and Boo Love. Welcome to the members. Evangelist Alicia, Tanya Lewis, Too Real. Thank you, Miss HST, for assisting me with reaching my goal. I appreciate you. Chanel, Marcella. I I think I got everybody. Okay, so let's get into it, y'all. Right now, what we're going to do is we're going to go over the entire case summary. And then after that, I think that it's important that we go ahead and get into the motion that Quadasia Johnson's attorney filed and what her reasoning is behind believing that she should be released. Now, I believe that that's important because it gives somewhat of a bird's eye view into what the defense is going to use to defend Ms. Johnson. Okay, so let's get into the case summary. Some of it you guys saw already, but we're going to go over it again. Okay, so branch 66 case summary. All right, this was filed on December 4th, 2025. Offense, of course, we already know. First degree unaliving has the statute placed right there. Okay, gonna go down. Now, before we get into the entire thing, the first thing that pops up within the case summary when you look at the documentation is, of course, one of the first orders that was entered, and it is a healthcare order. People of the state of Illinois versus Quadasia Johnson. So this says this court finds as follows, and I believe some of y'all seen this already. The defendant has reported that she is suffering from the following health problems, which is pregnancy. I was unaware that pregnancy was a health problem, child. The defendant has reported that she has not received the following prescribed medications, which is prenatal care. The defendant has exhibited the following unusual behaviors. Pregnancy. Okay. It is hereby ordered that the defendant is properly evaluated related to the above issues by appropriate healthcare personnel. It was signed here. Let's go down. Okay, so let's get into the actual case summary, y'all. Of course, here it says people of the state of Illinois versus Quadasia Johnson. Okay, so the order was entered here that she be held in custody. Now, this also showed that, of course, the next court date was 12/23/2025 at 11:30 a.m. Let's go on to the next page. Now, this is the documentation from the actual pretrial detention hearing where it shows her charge of first degree unaliving. Let me go down so I can read my comments on this other screen. Okay. A Black Rider said, please, no offense. I do, I have nothing against you, Black Rider, but this is a live regarding a whole different topic. I can't entertain that content creator today. I'm doing actual commentary. Okay. Yeah, obviously I'm the big dog around here. I'm the talk of the town, baby. And let me just say this. I completely understand why, because I'm the shit. I understand and I get why people are using my name to obtain super chats and super stickers and cash apps at the end of the month, because I'm the greatest, just like Muhammad Ali said. So you ain't got to come in here and tell me that. That lady is the least of my concerns. Let's get back into this paperwork. So order after pre-trial detention hearing, defendant appeared in person. Of course, we know that. Upon hearing the state's petition to deny pre-trial release, the court finds that one, the state has shown by clear and convincing evidence that the proof is evident or the presumption great that the defendant has committed an eligible offense listed, and then it shows the law code. Defendant and victim each have a child with witness one. All parties got into a dispute near a school. Defendant threatened V multiple times in front of witnesses. The defendant then retrieved a handgun, pew-pewed victim multiple times in front of witnesses. Victim succumbed to her injuries. The defendant poses a real and present threat to the safety of any person or persons of the community based on the specific articulable facts of the case. The defendant unalived victim after victim had just dropped off her child at school. The defendant celebrated unaliving her immediately after. The defendant was undeterred by presence of witnesses, public setting, broad daylight, near a school, and near many children. multiple civilian calls to 911 before and after the unaliving. No condition or combination of conditions set forth in, and then it has the law code. Let me know if you guys need me to slow down, okay? So let me start that section 3 over. No condition or combination of conditions set forth in the law code can mitigate the real and present threat to the safety of any person or persons or community based on the specific articulable facts of the case. Less restrictive conditions would not avoid a real and present threat to the safety of any person or persons or the community based on the specific articulable facts of the case. Because, now this is the part that most of us have already seen. EM/HC, which is electronic monitoring / home confinement, would not deter defendant from harming the witnesses, committing new offenses, or complying with conditions of release, as electronic monitoring / home confinement require a high degree of compliance with rules to be effective mitigation. Defendant showed utter contempt for law and basic social norms, and for offenses under subsection B of section 407 of the Illinois Controlled Substances Act that the subject to law code, the defendant also poses a serious risk to not appear in court as required. So from this piece of documentation, we know that Quadesia has and will remain detained in Cook County Jail, because according to the state of Illinois, in layman's terms, she's a danger to not only the citizens of the state of Illinois, the public, the community, but she is also a danger to the witnesses. This is what the state of Illinois is saying. They're also saying that they cannot be fully confident that Quadesia will not run. They're also saying that, okay, in layman's terms. Now let's go on to the next page. I got my water, y'all. So it then goes on to say, the proof is evident, or the presumption great, that the defendant has committed an eligible offense listed in this law code. I'm going to read over what that law code is after I'm done with this documentation, y'all. But I think most of you guys know that that is the law code in the state of Illinois that kind of breaks down what elements are required in an unaliving to be considered an actual act of self-defense. But we're going to go over that later. No condition or combination of conditions set forth in that law code can mitigate the defendant's willful flight. Less restrictive conditions would not prevent the defendant's willful flight from prosecution. Again, they believe that she's a flight risk for whatever reason. Thank you, Chandrika, so much for that super chat. Chandrika said, let's support the host. It's facts over feelings. I know that's right. Help me reach my goal. Thank you so much. I appreciate y'all. It is here, but it goes on to say, it is here, and this was just, to make sure that you guys are following. This was entered on December 4th, okay? So this is, again, from the detention hearing. It is hereby ordered that the defendant shall be detained and remain to the custody of the Cook County Sheriff pending trial and be brought to all court proceedings as required. The defendant shall be given a reasonable opportunity for private consultation with counsel and for communication with others by visitation, mail, and telephone. Okay, and here at the bottom is signed by the judge on the date of December 4th. Now, here on the next page is the court complaint transmittal listing, which was also entered on December 4th. And it's upside down, so I got to read it kind of weird. But it's basically saying the date of her arrest here. Let's go here. just basically the details about the arrest, saying that she was detained, what date she was detained, details about the law code and the reason that she was charged. It also gives her legal name, her weight, her height, and all of that. So let's go on to the next one. This is showing the people of the state of Illinois versus Quadasia Johnson. The undersigned as the attorney appears in the appearance of Quadasia Johnson, basically saying that she is showing that she has counsel, who is Ari Williams. So this is what this court order is, just showing that she made an appearance with her attorney. Again, December 4th. Let's go on down. Pretrial services, public safety assessment. So this is an assessment based off of Quadasia's history, criminal history, and what it looks to be that they actually use a scale once you are incarcerated here, and it says that she has reached level 2. So this, when you go down and look at it here, she reached level 2 as far as new criminal activity scale, and failure to appear, she's reached level 2. It goes on to get into her risk factors. It says her age, of course, we know that she's 31. Current violent offenses, yes, obviously we know that she has current violent offenses because she's in jail now for a violent offense. Current offenses and 20 years old or younger, no. Pending charge at the time of offense, no, she had no pending charges at the time of the offense. Prior misdemeanor convictions, yes. So we do know that Quadasia does have prior misdemeanor offenses. And from what I remember, oh, is she playing my life? Listen, please don't come in here mentioning that other content creator because I'm trying to focus. But if she is playing my live, when I get off of this one, then I'll take care of that. But I appreciate you, Zoe Ryder. But let me focus, okay? Prior felony convictions, no. So she doesn't have any felonies. Now, the misdemeanor that she does have, I believe it was retail theft, if I'm correct. So she does have a prior conviction for that. She has 0 prior violent convictions. Prior failure to appear in the past 2 years, 0. Prior failure to appear older than 2 years, no. Prior sentence to incarceration, no. Okay. All right. Now let's go down. This part obviously looks to be redacted for some reason. Okay. Petition for pretrial detention hearing. Okay, let's get into this one. I'm drinking sparkling water, y'all. So it's kind of making me belch a little bit. So this is her petition for her pretrial detention hearing in the circuit court of Cook County, Illinois. People of the state of Illinois versus the defendant Quadasia Johnson, charged first degree unaliving, has her IR number here. So the state is filing this verified petition for pretrial detention because the defendant is charged with a detainable offense under that law code we talked about that we're going to get into. The state is requesting a detention hearing where it will show by clear and convincing evidence that a forcible felony was committed. Okay, the defendant poses a real and present. I guess I don't need to zoom in. The defendant poses a real and present threat to the safety of any person or persons or the community based on a specific articulable facts of the case. Okay, so that's the box that's checked here. Number 3 says no condition or combination of conditions set forth with the law code can mitigate that risk. Under penalties as provided by law pursuant to section 1 through 109 of the Code of Civil Procedure, the undersigned certifies that the statements set forth above are true and correct, except as to matters stated to be on information and belief. As to such matters, the undersigned verily believes the same to be true. Again, filed on the 4th. Okay, now we've already gone over the proffer And I believe that her attorney already, well, we haven't gone over it, but we heard, what's her name? Miss Ewing. We heard Miss Ewing go over the proffer. But if, since it's here, if y'all want me to read it, I can read that too before we move on. So this is the proffer. Now, Ari Williams also mentions the proffer in her motion to have Quadeja released on this day of at the detention hearing. Okay, so we're gonna again later on go over that motion. It's kind of long, but we're gonna go over it. But first, what the hell? Let's go ahead and read the proffer again. So, of course, as we know, defendant proffer Quadeja Johnson, first degree unaliving. Victim 1 RB, which stands for Romeca Blackman, 31-year-old female. Incident, obviously, September 8th, 9:04 a.m. at 20 West Cermak. Witness 1 has a 6-month-old child in common with the defendant, as well as the 6-year-old child in common with the victim. In December 2024, the defendant sought a stalking no contact order against the victim, alleging that the victim made verbal threats to the defendant through the defendant's family members. The defendant did not allege that the victim committed any acts of violence against her. The order of protection was granted in July of 2025, but was never served on the victim. As the date of the incident, the defendant and the victim had never met in person. On September 8th, 2025, just before 8:30 a.m., Witness 1 drove his black Mercedes SUV from his home located on South State Street to the location of 20 West Cermak. The defendant was seated in the front passenger seat, and the 6-month-old child was in the rear in a removable car seat of the Mercedes. The defendant was dressed in a black jacket with green leggings. Witness 1 double parked his Mercedes on Cermak 2 car lengths in front of the defendant's black Chevy Cruze. The defendant and Witness 1 then removed their child from the Mercedes and walked towards the defendant's Chevy and loaded the child into the defendant's vehicle. Thank you so much, Chandrika. At approximately the same time, the victim drove her white Kia sedan to a school located at 55 West Cermak. The victim was dressed in a light pink outfit. She dropped her 6-year-old son off at the school and then drove to where the defendant's Chevy and Witness 1's Mercedes were parked on Cermak. The victim double parked her Kia on Cermak behind Witness 1's Mercedes and got out. And we all know Witness 1 is Carlos. While the defendant stood outside the car. Let me read that one more again. The victim double parked her Kia on Cermak behind Witness 1's Mercedes and got out, while the defendant stood outside of her car. At this time, Witness 2, who does not know any of the parties, drove past the victim, defendant, and Witness 1, observing the defendant and victim standing in the street arguing, but unable to hear exactly what was being said. He observed Witness 1 standing in between the defendant and the victim with his arms extended, and then observed the defendant advance toward the victim. Thank you so much, Philly Girl Juice, for that super chat. I appreciate you. As Witness 1 held the defendant back. Witness 2 observed Witness 1 push the defendant away from the victim, while the victim, unarmed, stood stationary with her arms crossed across her chest. Minutes later, Witness 3 was on an eastbound bus that drove past the defendant and victim as they argued. She observed bus video captured the victim and Witness 1 standing in the open driver door area of the victim's Kia. Okay. At this same time, Witness 4 was walking east on Cermak, approaching State Street. Witness 3 got off the bus, walked across Cermak, and stood under the CTA green line stop near Witness 4. Thank you, Beverly, so much for that super sticker. I appreciate you, boo. Witness 3 and Witness 4. who also don't know any of the parties involved, observed witness one standing in between. Now, before I move on, I want you guys to pay attention to something. Witness number two, who observed Carlos pushing Quadeja away from Romeca, that's what he observed, right? And he observed Carlos standing in between these two ladies. Now, witness 3 and witness 4, I'm gonna get into it, but they also witnessed the same thing. So what I want you guys to take note of is that witness 1, who has no relation, nor does he know witness 3 and 4, are all reporting the same thing. More witnesses will come out later, but from what we can see for now, these witnesses who are completely unrelated and don't know each other are reporting seeing the exact same thing, which is Quadeja by Romeca's vehicle and Carlos pushing Quadeja and standing in between these two ladies. Now, at this point so far, 3 people are reporting the same thing. Okay, keep that in mind. Shout out to Evangelist Alicia for that super sticker. I appreciate you. Brittany says stupid can't play with smart. I know that's right. Thank you for that super chat. So let's get back into it. Okay. So minutes later, witness 3 was on an eastbound bus that drove past the defendant and victim as they argued. She observed the bus video captured the victim and witness 1 standing in the open driver's door of the victim's Kia. At this time, witness 4 was walking east on Cermak, approaching State Street. Witness 3 got off the bus, walked across Cermak, and stood under the CTA Green Line stop near witness 4. Witness 3 and witness 4, who also don't know any of the parties involved, observed witness 1 standing in between the defendant and the victim. They observed the victim walk towards the driver's door of the Kia, and we know the Kia is Romeca's vehicle, standing in the threshold of the driver's door with witness 1 standing immediately outside of the driver's door. The defendant was standing on the sidewalk arguing with the victim. Witness 3 observed witness 1 strike the victim by repeatedly swinging the driver's door of the Kia closed on her. Witness 3 called 911 and reported that witness 1 had struck the victim multiple times with the car door. After her 911 call, the victim entered her car. Witness 3, now keep that in mind also. After the call, it says that Romeca got inside of her car. Now, witness 3 and witness 4 then observed the defendant approach the victim's car and heard the defendant making threats towards the victim. Witness 3 walked closer to the incident at this time. She then observed the victim exit the Kia, and when she did, observed witness 1 approach the victim from behind and place her in a chokehold with his right arm while striking her with his left. Witness 4 observed the victim unarmed with her hands in the air, trying to break free from victim 1's grasp. Victim 3 heard the defendant make threats to pew the victim and heard witness 1 tell the victim that the defendant had a gun. The defendant then went to her vehicle and was observed by witness 3 retrieving a handgun and then stand on the sidewalk. The victim was The victim was able to break free from witness 1's hold and took steps away from the defendant, as observed by witness 3. Witness 3 then observed the defendant point her handgun at the victim, walk toward the victim, and then fire multiple times at her, with a pause between the first shot and the subsequent shots. Thank you, No More Drama, for that super sticker. I appreciate you, hon. Witness had just turned to walk away when he heard one gunshot a pause, followed by 2 more gunshots. He looked toward the direction of the gunshots and observed the defendant holding a black handgun in her right hand. The victim was struck multiple times and collapsed. Witness 3 observed witness 1 move the victim's body and move her slightly west. Okay, so what I do remember, thank you so much, Buttercup, for that super chat. I appreciate you, hon. So I do remember initially when the proffer, let me pause really quick. When the proffer was initially read, I remember it being saying that Romeca's body was moved westbound. But when you look at the documentation, it does show who exactly moved her body. And according to witness 3, the body was moved by Carlos closer to Quadasia's vehicle. Okay, so the victim was struck multiple times and collapsed. Witness 3 observed witness 1 move the victim's body and move her slightly west. She then called 911 and reported that the defendant shot the victim. Witness 3 observed witness 1 and the defendant fist bump afterwards. Officers arrived and observed the victim unresponsive, unarmed, and laying in a pool of blood. They observed that she had been shot in the face and in the leg. Witness 1 was still on scene and covered in blood. The defendant was also on scene and had blood on her pants and hands. The victim was transported to the hospital and pronounced deceased shortly thereafter. Sorry, I had to take a break to drink some water. Excuse me for pausing. Witness 2, witness 3, and witness 4 were all still on scene when the officers arrived. Witness 2 identified the defendant on scene as one of the women he saw arguing minutes earlier. Witness 3 positively identified the defendant on scene as the shooter. The defendant was detained and admitted to shooting the victim. From her Chevy, officers recovered 1 loaded 9mm handgun. Evidence technicians processed the scene, recovering 3 9mm spent shell casings. Ballistics analysis revealed that all 3 of those spent shell casings were fired from the defendant's 9mm firearm recovered from the Chevy. The defendant refused medical attention and was transported to the police station, where she claimed self-defense and acknowledged that this was the first time that she had ever seen the victim in person. The defendant did have a valid FOIA card and CCL at the time of the shooting. Thank you, Teresa, so much for your super sticker, your super chat. Thank you, Lady Storm, for your super chat. I'm new to your channel. Thank you for your diligence on this case. Thank you so much. I appreciate it. And I appreciate you all for helping me reach my goal. Background: 2014 misdemeanor retail theft out of Lake County, for which she received supervision. So if you guys remember earlier, we did see that it is, hold on one second, y'all. We do see above where, sorry for the pause, y'all. It does say that she did have a misdemeanor conviction on her background. So I'm assuming that this right here is what that misdemeanor is, okay? A couple of things that I did want to point out though before I move on, because we got more documentation to go over. So I don't want to keep y'all all night long. But where is it at? Let me go up. I think that this is the part that was entered into the proffer here that is really important to the validity of the witness statement. Is really important that we understand it. A lot of these parties that are involved, as far as the witnesses, do not have any personal relationships with each other. I also want to point out that, let me see if I can find it. I don't want to spend too much time. I also want to say that now, from reading this, I can tell just from reading it that witness 3 and witness 4 are the Hispanic victims. Those two are related, they know each other. But witness 3 and witness 4, they do not know witness 2. Witness 2 is a completely separate entity. He does not know these people that saw the rest of this confrontation. So I think that it's very important to note that witness 2 is statements are matching witness 3 and 4 statements. Okay, let's go down. Okay, then of course, you know, this is her the final approval for her arrest. Okay, it says that she was arrested on the sidewalk, so I guess she was outside when she was arrested. I don't think that this is important enough to go over because we've already seen her mug shot. So let's go down. Okay, we don't need to read that either. This is just her arrest report. Okay, and I think we read her. We've already seen her arrest report, but just for the sake of reading, just for the sake of the documentation, I guess I'll read it again. 1 in custody, address of arrest gives the address of her arrest in Illinois. Charge is unaliving, court to be determined. In summary, this is an Area 3 homicide investigation support team arrest. Arresting officers had a conversation with Detective Torres regarding an ongoing homicide investigation of Romeca Blackman. This conversation revealed that Johnson Quadeja was positively identified as the person who shot Blackman, Romeca resulting in her death. Armed with a photograph of Johnson Quadeja obtained via Chicago Police Department data warehouse, arresting officers set up surveillance on Johnson's residence. Subsequently, Johnson Quadeja was located and taken into custody without incident. Johnson was transported to Area 3 clear leads. This is a BWC event. Okay, so let's go down and see what else is here. Again, this is more of her arrest report where basically it just shows who the arresting officers are here. It has that listed. Okay, so obviously this was on December 3rd. Okay, let's go down. Okay, so here is the rest of her report. It shows that she was transported after her arrest to the holding facility, obviously Cook County Jail, District 19 female lockup place. It also goes into showing that on this day she was placed in a 1-person cell. So she was in a cell by herself at that time. She was transported by 1 police officer. And then it goes in as a visual check of the arrestees as well. I can't read the chat. I'm so sorry because I'm on a different screen trying to read this, so it's hard to keep up with the chat. So I'm not ignoring y'all. I just can't do it 2 things at once. So basically they go over the specifics. Is there any obvious pain or injury? No. Is there any obvious sign of infection? No. Under the influence of alcohol? No. Signs of alcohol, drug withdrawal? No. Appears to be despondent? No. Appears to be irrational? No. Carrying medication? No. If female, are you pregnant? It says yes. First time ever being arrested? No. Attempted unaliving? No. Transgender? No. Deaf, hard of hearing? No. Interpreter needed? No. Serious medical problems? No. Serious mental problems? No. It goes on to asking about prescription or medication information. She's not on any prescription or medication. So let's keep going down here. And then of course, all of this is the same stuff. So it just goes over who the lockup keeper was, who the arresting officers were, and all of this. Okay, so let's go down. So this is the felony complaint. It says State of Illinois / Detective Torres. Now, as we know, Detective Torres was one of the investigators for this case. It goes on to say Romeca Blackman is the complainant, now appears before the court. And obviously, That's just the way that it's written because Romeca, unfortunately, is lost her life. She's deceased. Her name is just placed there because she's the victim. Um, Without lawful justification, the offense of first degree murder was committed without lawful justification and with the intent to kill or do great bodily harm to Romeca Blackman, or another person shot Romeca Blackman, thereby causing the death of Romeca Blackman. And then it shows that she's in violation of code 720 ILS CS 5.0. Okay, so let's go down. Okay. Okay, so we're going to get off of this one, and then we're going to get into the motion. Now, this is, now, again, I think that this is really interesting because this really gets into what, to be honest with you, it shows the hand of the defense and what they're probably going to say and try to use in Quadacia's offense. Give me a small intermission. I'll be right back.
She a debater, baby. She can give it to you straight, no chaser. She got the smarts. She got the heart. She got the confidence. Baby, she the upper echelon. You know you intimidated. Stupid can't play with smart. She got the smart. She got the heart. She got the confidence. Baby, she the upper echelon. You know you intimidated. Stupid can't play with smart. 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 Stupid can't play with smart.
Okay, I'm back, y'all. All right, let's get into it. Let's see, what did I miss? I want to say thank you to Miss Duncan for that membership. I really appreciate you. Thank you so much. Hold on. I missed somebody. Got Miss Duncan. Oh, okay. Let's correct that. Okay, I'm glad I looked at the comments. TLC is saying no. Witness 4 is not the boyfriend. Okay, so let's go back then. Let's go back. Let's correct that. That's why, it takes, it's teamwork make the dream work. So let's go back. I don't mind correcting myself. Let's go back. So let me highlight this too so that we know we see that. Where are you at, TLC? Let's go up. Let's go up. Okay, so witness 4 is not the boyfriend. Okay, so witness 3, I'm assuming, correct me if I'm wrong, witness 3 is the Hispanic woman. Witness 4 is not the boyfriend. Witness 4 is a separate person, which makes it even more interesting because, again, these people are unrelated. Okay, wow. So witness 2, witness 3, and witness 4. Correction, witness 4 is not the boyfriend. Okay. So, okay. So that makes it even more interesting because none of them are related. And when I say related, I mean none of them are know of each other, but seem to have. Okay, so let's go back here. Okay. Now let's get into the filing. Let's get into the this is the motion. Purple Butterfly says, who is number two? TLC, do you know? I don't know. I don't know who witness number two is, but he's separate from the other. All of them are separate witnesses. Matter of fact, let me look at I think it's worth looking at my comments before I move on because I don't want to have to keep stopping. Let me go down and read my comments, y'all. Once the trial hit, a judge will be once the trial hits, a judge will be assigned. That's what Philly Girl Juice said. KB Mommy says, "Thank you, sweet queen." And the same to you. The judge has not been assigned yet. What's going on, Lady Love? Hey, boo. Hey, Ebony. So basically, I'm seeing the same questions about the judge. Purple Butterfly says, "I can't believe all this evidence. Is it true? There's more than these. From what I'm understanding from yes, there's more witnesses. Heard these videos and witnesses from the building across the street. I want to say the security guard saw it go down too." Miriam says the other side defense case is weak and they keep ignoring the gun involved and focusing on the wrong things. Thank you, Chandrika. Evangelist Alicia. I can't read what that says for some reason. Hey, Linda. Okay, let me read this really quick. Akira says, "I see them downgrading charges if her attorney is good. Fact is, Romeca pulled up on her and Carlos started an argument and had a restraining order, whether served or not. Shoes threat to suspect prior." I'm not sure what that last part means. But I do have a question for you, Akira. From what I did understand from that comment, you said the fact is that Romeca pulled up on her and Carlos and started an argument. My question to you is, do you have any evidence of that? Do you know that she pulled up and started an argument? Is that a fact, or is that just what you think happened? Okay, so you let me know that in the chat. If that's something that you know factually, and if you do know that factually, how did you get that information, and where did you get the information from, so that I can look through it and also see how and see the validity of that statement. Because in order to make a statement like that, you have to have proof. And to my knowledge, there is no proof of anyone showing that this is what happened and why it happened. So not only by this statement are you saying that you know exactly what happened, but you also know the intent of why it happened. So you somehow have the evidence of what happened that day, why she pulled up, and somehow you are able to know what she's thinking and what her intent was by pulling up. How you know that, I don't know. But if you can forward that information over to my inbox on Facebook, I would love to look over it. Now let's go down. She is the one that is doing the arraignment hearing. She will assign the case to the judge. Nisham says, "I don't give a damn if she did pull up and start an argument. That's no reason to shoot someone because you have a see." You know what, Nisham? People are going to see that very soon. Very, very soon. Carlos and Romeca weren't arguing. They were talking. S. West says, "Exactly." Boogie said, "What's an argument compared to a life, though?" Hey, E2 Short. Ebony said, "I wouldn't tell any of the witnesses' name for privacy reasons because people are crazy." I don't think they put the witness names inside of the document, though. I think that's the reason why they're labeling them witness one. I think the public really, because this is a public doc, so I think the public can read this and kind of just, assume who is who. You know what I mean? Oh, I have heard that. I don't know how true that is, though, Lady Love. Sherry said when Carlos announced she has a GUN, Holly went to go get it. Carlos was there abusing Romeca, lock Carlos up and keep Holly in jail. I gotta agree if that's how it happened. Carlos said they was just talking on his live. Oh, really? Is that what he just said? Somebody sent a screen recording to me. Ebony said, rather Romeca pulled up and got out to talk to Carlos. No one deserves to be unalive just because she pulled up. I agree. She did upper. Oh. No caller ID says, so I was on another content creator page and they were reading the autopsy, and Carlos literally crushed her thyroid from choking. You know what? I was sent a screenshot from, I'm gonna get into this documentation in a minute, but I was sent a screenshot showing I was sent a screenshot where somebody actually wrote that on Facebook, but I just did not see I haven't seen the full autopsy report, so I can't verify that. But if that happened, that is insane, and it really shows what type of force that he put behind choking her. And I want to say that check this out, y'all, and this is why it's so important, because a lot of people were really saying that the case was closed because it was taking so long, but they also had to wait for certain reports like the toxicology screening, the autopsy report, and everything like that. Now, if that's what the autopsy report says, of course, I haven't seen it. If somebody wants to send it to me, I'd be more than grateful. But if the autopsy report does say that her thyroid was crushed, because of her being restrained and choked by Carlos, that shows even more that during the pew-pewing that she clearly, how are you a threat with a crushed thyroid? How are you still trying to fight with a crushed thyroid? These that need answers. Need answers. I want to see that documentation. I don't want to just keep saying it if I haven't seen it, but oh, did she listen? Oh, okay. You know what she did? Still hear me? How's my sound? Is my sound good? You know what? Because I did read over it earlier. I already did list names. 760. The question is, why were Quadeja and Carlos across the street from the school? Where was Quadeja parking before? That's my thought process as well. All right, y'all should be able to hear me now. Matter of fact, drop a 1 if y'all can hear me. Drop a 1 before I get started. Thank you. Thank you, Melanin Queen. I appreciate that super sticker. And thank you, Tammy Van. Let me see if I missed anybody. Y'all should be able to hear me now. Let me see. I appreciate y'all. I think I gave y'all a members only maybe like a week or so ago. Maybe. I want to give you all another one. I want to say by next week, Wednesday or Tuesday or Wednesday, depending on my schedule. Hold on. All right, let's get into the document. Let's get into the paperwork. I ain't gonna keep y'all waiting for too long. Let me exit this out, pull this up. Okay, so y'all can hear me clear. I had to change my internet source, y'all. Sometimes I got to do that. I got 2 internet sources at my house, and sometimes for some reason, maybe it's the location of my setup. Maybe I need to change my setup location. Okay, so let's pull this down. All right. So here's the motion. In the Circuit Court of Cook County, Illinois, Criminal Division, People of the State of Illinois, plaintiff versus Quadeja Johnson, the defendant, to Assistant State's Attorney, Cook County. Notice of filing. I don't think that I need to read that part. If y'all want to read it, screenshot it. But I don't think that part is important here. Just showing that Ari Williams is the attorney for Quadeja Johnson. It also goes into proof of service. Okay. I personally don't feel like I need to read the first 2 pages because I don't think it's whatever, but I will, if just for the sake of the live, I will, I guess. Motion for relief pursuant to Illinois Supreme Court 604. In layman's terms, motion to be released. Okay. Now comes, and then, so as I get into this document, okay, so just bear with me for the first couple pages. But as I get into this document, it is going to get into what I believe the defense is going to use in the event that this case goes to trial. Miss SHST says, I don't think the report said her thyroid was crushed. I don't know. Like I said, I haven't seen it. But if somebody has it, you can send it to me. Okay. Now comes the defendant, Quadeja Johnson, by and through her attorney, Ari Williams, and respectfully request this honorable court to review its decision entered July 9th, 2004, after hearing pursuant to the Pretrial Fairness Act. On or about September 8th, 2025, defendant was arrested for the offense of first-degree unaliving, among other charges. On December 4th, 2025, Ms. Johnson appeared for her initial detention hearing. Number 3, following the hearing, Ms. Johnson was held in detention. Now, again, you guys pay attention. This was a motion put in by Ari Williams, her attorney, to have her released, and the reasoning that she believes that Quadeja should be released pending trial. Okay. Number 4, the state of Illinois has abolished the requirement that a defendant post monetary bail in order to be granted pretrial release from custody. This law was originally set to go into effect January 1st, 2023. On December 31st, 2022, the Supreme Court granted a supervisory order staying the effect of the pretrial release provisions that abolish monetary bail in Illinois. However, on January 18th, 2023, in Roe versus Raoul, the court held the public acts abolishing monetary bail where constitutional, and the court further ordered that stay out of pretrial release provisions was vacated as of September 18, 2023. Y'all, please just bear with me through this. This is the boring stuff, okay? But I assume that some people may want to hear it. As of September 18th, 2023, a defendant may only be denied pretrial release upon the filing of a verified petition by the state after the court holds a hearing and makes required written findings. Upon verified petition by the state, the court shall hold and may deny a defendant pretrial release only if the defendant's pretrial release poses a real and present threat to the safety of any person or persons or the community based on a specific articulable facts of the case and the defendant is charged with a forcible felony. Number 6, pursuant to ILRSCT Rule 604, Following a detention hearing and as a prerequisite to appeal, the party taking appeal shall first present the trial court with a written motion requesting the release sought on appeal. The motion for relief shall be promptly heard and decided by the trial court prior to filing appellant's notice of appeal. The court may only deny pretrial release, and this is number 7. A court may only deny pretrial release if the defendant fulfills one of 6 categories of offenses and meets the corresponding standard of threat to the complainant and has a high likelihood of willful flight to avoid prosecution. Number 8, when it is alleged that a pretrial release should be denied to a person upon the grounds that the person presents a real and present threat to the safety of any person or persons or the community based on the specific articulable facts of the case, the state bears the burden of such allegations. Number 9, additionally, at all pretrial hearings, the prosecution shall have the burden to prove by clear and convincing evidence that any condition of release is necessary. Now, we got through all of that. Basically, the beginning of the motion is stating what the law are regarding release of detention in Illinois. Now she's getting ready to get into the argument of why she believes her client should be released based off of those stated law codes, okay? I also believe, and I think it's pretty obvious, that the defense is going to use these arguments in the event that this goes to trial. So for anybody that's just coming in the room, what I'm getting ready to read is something a motion drafted, the argument within the motion drafted by Ari Williams, who is the attorney for Quadasia Holly Johnson. She gives reasoning as to why her client should be released. And she also gives reasoning behind why she she should be released. And then also from how I see it and interpret it as well, it looks like she's giving kind of a bird's eye view as to what her defense may look like. So let's get into it. Hey, Harm. Thank you. Make sure y'all hit the like button. Okay. Excuse me, y'all. I'm drinking sparkling water. So excuse me. Okay, so number 1. There has been a change in circumstance. So this is what Ari is saying. There has been a change in Can you make sure just to check, just to make sure. I want to make sure my audio is good. So please drop ones in the chat if my audio is good. There has been a change in sufficient to warrant a redetermination in Quadasia Johnson's detention status. In recent cases, the appellate court has held that a circuit court must find change circumstances before it alters an existing order to detain a defendant. People versus Cervantes, 2024. See also People versus Walton, 2024. People versus Thomas, 2024. The court in Walton reasoned that a decision to detain, however, requires no ongoing management by the court, and there will likely be no reason to revisit it unless circumstances have changed or new information has come to light. People versus Walton, 2024. In the present case, there has been a circumstance significant enough to warrant a redetermination of Ms. Johnson's detention status. Since Ms. Johnson's last detention hearing, y'all, counsel has since had the opportunity to speak with her family, review discovery, and understand more case than was previously proffered, as well as Ms. Johnson's background. This information constitutes a change in circumstance sufficient to warrant a redetermination of Ms. Johnson's detention status. Where this court solely relied on allegations that were made against Ms. Johnson To initially determine her custody status, this court should consider its ruling and order less restrictions for Ms. Johnson's release, consistent with Illinois law. And then she enters the law code here. Number 2, the state is unable, now this is her second argument for to get Miss Holly released. The state is unable to meet its burden, proving by clear and convincing evidence that the proof is evident and presumption is great Quadesia in fact committed this offense. The circumstances and facts of this case do not weigh in favor of any of the factors courts consider when determining whether a defendant poses a real and present threat to the safety of any person. The state bears the burden of proving by clear and convincing evidence that the proof is evident or the presumption is great that the defendant has committed an offense listed in said law code. Regarding the charge, the state has the burden of proving that Ms. Johnson had the intent to kill the deceased Romeca Blackman without lawful. 720 ILSCS 5/9. The state cannot prove this by clear and convincing evidence. The state cannot prove that Ms. Johnson intended to kill or do great bodily harm to the victim without lawful justification when Ms. Johnson acted in defense of herself and her 6-month-old son. So as you can see, this is the, let me get my highlighter or whatever this is. This is what they are going to be heavily relying upon if this case goes to trial. They're going to be relying very heavily on the presence of the child, okay? Which is why I'm reading this. Like I said, it gives a good bird's eye view of what the defense is going to look like, okay? So this motion gives a bird's eye view to not only us, but also the prosecution. In establishing self-defense, the defendant must show some evidence that the unlawful force was threatened against them. The danger of harm was imminent. The defendant was not the aggressor, that she actually believed that a danger existed. Force was necessary to avert the danger, and the type and amount of force was necessary, and that her beliefs were reasonable. People versus Hawkins. Additionally, whereas the law does not require the aggressor's arm for self-defense to be justified, it must appear that the aggressor is capable of inflicting serious bodily harm without the use of a deadly weapon and is intending to do so. All such aforementioned factors have been met in this case, and such is as follows. What the state has failed to capture and sensationalize throughout the reporting of this case is the reality and the truth the victim has had consistently and through various means threatened the use of unlawful force against Ms. Johnson. Ms. Johnson, her closest friends, her family members have all been subjected to the victim's insistent and concerning harassment, whether that be via unsolicited calls or text messages. December 4th, 2025. Okay. And I believe that that is the order of protection that Holly obtained is what she's referring to. Okay, so again, I'm just reading what the defense is probably going to be. Okay, I'll get into doing commentary on what my opinion about it in a minute. Okay, thank you, Josephine, for that super sticker. I appreciate you, hon. Okay. Ms. Johnson has continuously been threatened by the victim on her cell phone to the extent that Ms. Johnson had to block the victim's phone number. The threats from the victim were relentless, even having gone so far as to find Ms. Johnson's grandmother's phone number, calling her grandmother, and making it clear that it was her intent to kill Ms. Johnson. Now, as we read this, understand that all of these things that Ari is saying must be proven. Okay, so that has to be put on the forefront. She's saying these things, but these things have to be proven. Okay, just like the prosecution has to prove that they have reason beyond or proof beyond a reasonable doubt that she did what she did, Ari's argument has to also be proven as well. Documentation must be shown if documentation exists, because anybody can just say that they were threatened. Anybody can just say that somebody called them. Again, I also want to make sure that I throw out there that even after this motion was denied by the courts. I want to throw that out there. This was denied by the courts. We know this because Holly is still in jail. Okay, so let's keep reading what her reasoning was. Where did I stop at? Okay. The unlawful use of force threatened against Ms. Johnson by the victim were grave and real. Ms. Johnson was genuinely concerned for her safety, given that she was pregnant at the time. She was receiving threats that the victim was going to end. I don't mean to stop, but how far along is Quadeja? Because what I find interesting is that, and I'm gonna go back to the paperwork, but it states that she's pregnant when they arrested her. And then it also states that she doesn't know how far along she is. So she knew she was pregnant, but she didn't know how far along that she was pregnant. Okay, so that'll be interesting to find out. And receiving threats that the victim was going to end her and ultimately her child's lives. Ms. Johnson's concern led to her obtaining an order of protection against the victim in December of 2024. This order of protection was granted in July of 2025. So initially, Quadeja went to obtain an order in December of 2024, and it wasn't granted until about 6 or 7 months later, a few months prior to the incident. Okay. The victim was served with this order of protection and was aware that this order of protection was placed against her. A copy of the transcript for a June 18, 2005 hearing regarding the order of protection was tendered to the court. Hold on one second. Hold on. Let me pull. Okay. At Ms. Johnson's initial detention hearing. Let's see. So what I'm going to do is I'm going to pull this down. I'm going to continue reading. And the only reason I'm doing that is because going forward, there's certain names in here in the order that I don't want to read publicly. So let's see. Since we're not hearing the order, let's see where I left off. The transcript illustrated the victim's inherent aggression and hostility, not only towards Ms. Johnson, but towards the court as well. The court frequently asked the victim to stop and that she was doing nothing to help her case of why Ms. Johnson needs an order against her. Hence, Ms. Johnson was indeed shown and made clear that unlawful force was threatened against her. Further, the danger of harm was imminent where Ms. Johnson reasonably believed that a danger by the victim existed and that the use of force was necessary to avert the danger that the victim presented on the morning of September 8, 2025. After having spent the weekend at the residence of her 6-month-old child's father, Carlos Smith, Smith drove to Smith's black Mercedes to where Ms. Johnson parked Chevy Cruze. Smith's Mercedes was double parked 2 car lengths in front of Ms. Johnson's vehicle facing westbound. In moving her child from the rear seat of Smith's SUV, Ms. Johnson placed her child in the back seat of the Chevy sedan. At approximately 8:51 a.m., a white Kia sedan driving eastbound on Cermak is captured on camera making a U-turn facing westbound. Victim owned a white Kia sedan and used it to drop her son off at school on 55 West Cermak, the son whom she shares in common with Smith. The victim blocked Ms. Johnson's car by double parking her. Now, this is where we get into the lies. And see, this is actually part of the reason why I believe that this motion didn't work, because within this motion, there's a lot of what I would call basically, obviously, she's doing her job and she's trying to defend her client. But we even know from doing our own research online that Quadeja was not blocked in. However, there's certain things that she's putting in this motion that are simply just not true. And I really do believe that that's part of the reason why, even after she drafted this long motion, that the young lady still wasn't released. Okay. There's also a lot of things within this motion that she put in that has yet to be proven. I'm gonna read this last paragraph here, and then I'm gonna move to the comments, and then I'm gonna finish it out. The victim took it upon herself to approach Miss Johnson and Smith in an unsolicited manner, saying, "I told y'all I was going to catch y'all." Carlos, witness one, who is Carlos Smith, was speaking to officers on scene. An argument, this is what Carlos Smith told officers on scene. Also keep in mind that this is a report from Carlos, okay? An argument ensued between Miss Johnson and the victim. Miss Johnson pleaded with the victim to please leave me alone. Now, all of this stuff that's being reported, the victims have not corroborated these things, okay? The state argues, but we also know that the day that she unalived the victim was the first date that she had ever met her in person. And ultimately, if the victim was coming for violence, then maybe any victim out there would have seen the victim attack either the defendant or witness number one, and that never happened. Okay, let me read some comments before I continue. Let's see. No recent pregnancy, October 6, 7, 8-ish, Los Vide, 7 weeks later. December arrested. The celebrated was the fist bump. Los say math ain't mathing though. I don't know. How could he remember that also? Well, Golden Girl, that was a yeah, I got that bitch, and yeah, we got away with the celebration. She's slow. Folks better listen. It's evidence that she meant to unalive her. She still knew she was supposed to be there. You're afraid, but you're at the son's school. Yep. Said Holly was the problem. You are right. You played yourself, said so. That's why nobody's seen Holly. He was so far up. That means she was pregnant 2 weeks after the unaliving. I don't know. Don't take it personal, says the judge read that at Holly's arraignment and said Holly was the problem. Shell, okay, so let me finish. Okay, hold on 1 second, y'all. Hold on. Okay, so again, y'all, only reason I'm taking this down is because I don't want to show some of the names of the victims, just out of consideration, y'all. So what I can do is kind of just take some screenshots and put it in a video later on tonight or early tomorrow. But I'm not going to show the names of I'm not going to show the names of the victims, y'all. Not the victims, but the witnesses. Or what I could do is I could just blank it out and then pull it back up. The state argues, but we also know that the day that she unalived, I read that part already. Notably, yes, September 8th, 2025 was the first in-person encounter between Ms. Johnson and the victim. However, irrespective of it being the first in-person meeting between Johnson and the victim, encounter absolutely was enough to cause Ms. Johnson to be fearful of what the victim could do to her, especially given the victim's history of violent threats against Ms. Johnson. Okay. Again, at the time, Ms. Johnson had the order of protection against the victim. The victim had previously threatened to unalive Ms. Johnson, has sent numerous threatening and harassing messages to Ms. Johnson and family members, and the victim on the date of the incident was now advancing towards Ms. Johnson upon seeing her on Cermak with the man they shared children in common. This was absolutely enough to devastate the victim and make her distraught. I think they should have said defendant, distraught over the fact that there's another woman in the picture. Or maybe they did mean victim. Witness 1, Carlos Smith, stated to also, well, no, let me finish. Witness 1, Carlos Smith, stated to police 2 hours after the incident that the victim ran up on Ms. Johnson and swung at her face, making physical contact with Ms. Johnson. Witness 1, Carlos Smith, was speaking to officers on scene. It says that in parentheses. The danger was absolutely great and imminent. I ain't gonna lie, y'all. I see why this motion didn't go through. Ms. Johnson did not know what the victim was capable of, or if the victim would follow through with her threats to unalive her. With her 6-month-old child in the backseat of her vehicle, Ms. Johnson was reasonably proactive and defended herself and her child. Again, given the history between herself and the victim, along the victim making physical contact with Ms. Johnson reasonably believed that the use of force was necessary to avert the danger that the victim was posing to her and her child. The state has, you know what? And then also, before I move on, I'm on page 7. Before I move on, matter of fact, this is what I'll do. Yeah, it got the names of it has the names of the witnesses. I can't show that. I don't want to show that. Leave this person. Okay. What I do find interesting though, y'all, from what I'm reading, is that the motion will be heard on January 7th. Okay, thank you, TLC. What I do see from what I'm reading, though, is that they're saying that her child was in danger, and that's the reason why she did what she did. However, from other documentation, witnesses saw witness 1 move Romeca closer to Holly's vehicle, meaning that at that time she was not near Holly's vehicle. Her body was moved towards Holly's vehicle, according to other witnesses. So that's going to be hard to prove because that the child was in danger because she was not near the vehicle. But let me move on. The state has also failed to prove that Ms. Johnson committed the offense when improperly relying on uncorroborated witness statements that is not supported by video evidence. When arguing that this has been proven by clear and convincing evidence that the proof is evident and presumption great that Ms. Johnson committed the offense, the state is only required to present reliable evidence to sustain its burden. People versus Phelps, 2025. Yet the state is unsuccessful in bringing forth reliable evidence suggesting that Ms. Johnson committed the offense of first-degree unaliving. Essentially, there is, so this is going to be shown on the next court date. Got it. Okay. I had to process that. Okay, so this wasn't presented at the last court date. Okay, note that, y'all. Notate that this wasn't shown at the last court date. Yet the state is unsuccessful in bringing forth reliable evidence suggesting that Ms. Johnson committed the offense of first-degree unaliving. Essentially, there is no video evidence at all capturing the pew-pewing, either from the POD camera at the intersection of State and Cermak or from the bus footage. So listen to that, y'all. Let me repeat that. The state is unsuccessful in bringing forth reliable evidence suggesting Ms. Johnson committed the offense of first-degree unaliving. Essentially, there is no video footage at all capturing the shooting, either from the pod camera at the intersection of State and Cermak, or she's saying that there is no footage of the actual pew-pewing. This is what her attorney is saying. Witness 2, 3, and 4 are all independent of each other. Now, this is the part I'm not going to show. Let me see what it says real quick. Okay. None of these witnesses observed the events of September 8th in its completion, and their statements are entirely inconsistent. For example, witness 1 stated in his interview that he drove eastbound on Cermak during the time of the incident to pick up a DoorDash delivery from Momentum Coffee. While driving by, Woods stated to detectives he saw both Ms. Johnson and the victim on the opposite side from his lane of travel, arguing with Smith in between them. The witness did not see either Ms. Johnson nor the victim displaying any weapons. Further, this witness was not present for the actual pew-pewing. The witness stated to detectives he was inside his car driving eastbound on Cermak, turned left on State Street, parked his car in front of Momentum Coffee, and was inside that coffee shop for 5 to 10 minutes. He was inside Momentum Coffee when the shots rang out. The witness further was only able to identify Ms. Johnson because she was the one placed in handcuffs, not because he saw her with the pew-pew in her hand shooting the victim. This is what, let me see what this message says real quick. Okay. Most importantly, witness number 3 is the state's star witness who sees most of it, but she put star in quotations, who sees most of it, but ultimately what witness number 3 hears and sees is threats being issued towards the victim by the defendant. Here's witness number 1 telling the victim that the defendant had a gun, heard the defendant making threats to shoot the victim. Yet the statements made by witness number 3 are wholly uncorroborated by the evidence, where the witness was seen walking in the opposite direction of the scene, crossing a busy street 350 feet away from the scene, had her view obstructed and hindered when she was hiding behind a wall under the bridge of the Green Line, and was seen wearing headphones that would make it difficult to capture an argument from 350 feet away. 300, that's not that far away. But let's keep on going. So what her attorney is saying that this witness is not credible because she has headphones on. She's saying that this witness had on headphones, and she believes that the witness would be too far away to hear or see what was happening at that time. So that's her belief. Let it be known that the witness headphones are so thick with probable noise cancellation features that the headphones hindered her from hearing any outside noise. This is evidenced by the witness removing her headphones and sliding them around her neck when officers attempt to talk to her about the incident once the officers arrive on scene. So her attorney is saying that she obviously didn't hear anything because she was wearing noise cancellation headphones. And when the police officers were speaking to her, she had to take them off to hear the police properly. So the attorney is saying that she could not have possibly heard the actual incident, despite the fact that the police officer was probably speaking, and during the incident, it was probably yelling. So we have to keep that in mind as well. But I see where she's trying to go with it. So as this witness inconsistencies in statements and observations, it was approximately 8:51 a.m. on September 8th when a white Kia sedan was seen making a U-turn on Cermak, now facing westbound. The witness was on the 21 bus headed towards the Green Line at 3:20 the statements were made at 3:28. Okay. Witness claimed to detectives that while she was seated on the bus that was nearing the intersection of State and Cermak, she looked to the left on her outside of the bus's window, saw 2 females and a male arguing, and the male was seen by the witness slamming the door on the female with red hair. The witness told the detectives that allegedly upon seeing the incident of Smith slamming the victim with the car door, She exclaimed, "Oh my God," as she was talking to her boyfriend. Then the attorney says, "False. Such events of her explanations are not captured on video footage from the 21 bus that she was traveling on." So the attorney, which we knew this is what attorneys do, they're going to try to discredit what the witnesses are saying, obviously. Okay. So she's saying that the witness said that she said, "Oh my God." So she's saying that that wasn't captured on camera. So the witness couldn't have possibly said that. Okay. So, hold on one second, y'all. Let me send this. Give me one moment. Hold on. Let's see. Okay. 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 As the witness is seen briefly looking out the left-hand side window and seen for 9 seconds, the witness turns her head forward, facing the front of the bus. The witness has no reaction on her face to the body slamming she just witnessed Smith do to the victim with the victim's car door. On that note, the victim footage from the bus does not capture Smith hitting the victim with the door. Additionally, the witness is not exclaiming anything, meaning she's not screaming, according to the attorney, making statements of any kind. She is not holding a phone, nor is she seen talking to anyone near or around her. Her mouth is not moving whatsoever. Instead, the witness is unaffected by the events. There are 9 minutes of the event that the witness did not see. She did not observe how the event began, nor any of the threatening behavior victim towards Ms. Johnson. Even then, the bus never made a complete stop at the intersection of State and Cermak. The bus continued moving eastbound on Cermak, driving through the light. Once the bus drives past the intersection, approaches its stop, the witness gets out of the bus with her stroller and continues to head eastbound on Cermak. The witness is traveling in the opposite direction of the scene and proceeds to do so, missing much more of the events between Ms. Johnson and the victim. The victim further alleges she was able to hear Ms. Johnson and the victim yelling at each other while she was on the bus. This is refuted completely, where the victim is wearing large, thick headphones over her head. And this is her assuming that the headphones were on, okay? Such headphones would make it impossible to hear exactly what was being said when witness 2 and 4 were unable to hear exactly what was being said. Again, witness headphones hinder her from hearing any outside noise. Evidence by the witness removing her headphones and sliding them around her neck, attempted to talk to her about the incident once the officers arrived on scene. Let's see. Let's see. Where did I stop at? Okay. Even once the witness was off of the bus, turning around the crossing Cermak to get to the sidewalk near the other lane of traffic, the witness approximately 350 to 400 feet from the scene. Not only would she be too far and too distant to hear the exact words coming out of Johnson and victim's mouths, victim was also too far to clearly see what was going on. In that same sense, the witness view was also obstructed by numerous times by a wall while she was making the second 911 call at 9:04 a.m. Witness is seen emerging from behind a building while she is under the Green Line Bridge that is outside the view of the scene. Further, the state fails to take into account the lack of credibility from the witness stories to which they are relying on. The state alleged that the witness also observed witness one and the defendant fist bump after. Only is this fist bump not only is this fist bump not captured on camera, but witness never mentions or exclaims such a thing on scene. Additionally, witness number 4. Okay, so she's trying to discredit all of the witness statements. Not going to work. Additionally, witness number 4's statement to the detectives on the case is completely unreliable and not credible. This witness is a crossing guard for the National Teachers Academy. This witness did not observe Ms. Johnson shoot the victim. This witness is simply assuming such is the case. When asked by detectives why he believes the victim was shot by Ms. Johnson, the victim claimed, just because of the fact she explained, from what I heard, she explained that she had a concealed to carry. So I just figured that her saying that is basically letting me put 2 and 2 together, that she actually was the one that pulled the trigger. The witness statements are based on hearsay and interferences that cannot be taken for true. Where Ms. Johnson has not been convicted of any of the offenses alleged in this case, Ms. Johnson has presumption of innocence. No evidence has been presented in this case that would rebut Ms. Johnson's presumption of innocence to meet the state's burden here. All evidence presented to potentially incriminate Ms. Johnson is circumstantial and cannot meet the state's burden. Okay. Okay, so let's go on. Where the state fails to meet its burden of proving by clear and convincing evidence that the proof is evident and presumption is great, Ms. Johnson in fact committed the offenses she is being charged with, this court should release Ms. Johnson from pretrial detention. Okay, so basically this here is a motion drafted for the next court date, y'all. So this attorney has also I believe this attorney filed this motion at the last court hearing. Let me know if somebody knows in the chat, but I believe that this was filed at the last court hearing. Maybe it hadn't been presented yet. Let me look. Okay, so let's go ahead and correct me in the chat if I'm wrong. Let me go ahead. So number 3, this is the third part of her argument. So let's just backtrack real quick, y'all, of what her argument is. So let me go up just as a review. Let me go up. And again, certain things I'm not showing because there's names in here and I don't want to identify the victims and put them in jeopardy. So as far as her argument, number 1 is that there is no change in circumstance sufficient to warrant a redetermination in Quadacia's detention hearing, and she used a certain law codes. The second part of her argument is that the state is unable to meet its burden of proving by clear and convincing evidence that the proof is evident and presumption is great. Quadacia Johnson has committed this offense. That's number 2. Now the problem here though is that a burden of proof or proof beyond a reasonable doubt is not needed to charge someone. That comes later on once we're going towards trial, once they're working on convicting Quadacia. So yeah, that's not needed at this point. Let's move on to 3. Okay. So she notified the state on December 22nd, filed the motion on December 23rd, and it was continued to be heard on January 7th at the arraignment. Okay, thank you, TLC. Let me keep going down. Okay, I read that part. Okay, let's get into number 3. Number 3 of her argument, because the state cannot meet its burden of proving by clear and convincing evidence that Quadacia Johnson possesses a real and present threat to the safety of any persons or the community. The state here cannot meet their burden of proving by clear and convincing evidence that Ms. Johnson poses a real and present threat to the safety of the community. The circumstances and facts of this case do not weigh in favor of any of the factors courts consider when determining whether a defendant poses a real and present threat to the safety of any person. A court may consider the factors articulated in Law Code 725. In addition to the specific articulable facts of this case, when determining whether a defendant poses a real and present threat to the safety of any person. Among these factors are the nature of the offense, age, and physical condition of the defendant, whether the defendant has access to a weapon, and any factors deemed by the court to have reasonable bearing on the defendant's propensity for violence. Sorry, y'all. In the present case, while the charge being brought upon Ms. Johnson is one of a violent nature, no evidence has been presented that Ms. Johnson did in fact commit these acts, let alone she poses a real and present threat to the safety of the community. Ms. Johnson has no violent background. She has a misdemeanor retail theft from 2014 out of Lake County, receiving supervision for that. She also has a prior misdemeanor conviction from 2015 for speeding. Ms. Johnson has no pending cases at this time. Where the state erroneously argues that Ms. Johnson is a risk and was emboldened by carrying her firearms, such is not the case. The state fails to see the gravity of harm posed to Ms. Johnson when confronted aggressively by the victim. Neither was this a twist. Now, let me stop this right here because I just thought about something. So let me say this. The attorney herself states, now this is new, y'all. The attorney states within this documentation, I'm going to put up certain screenshots of certain parts and redact certain parts too. But the attorney here states that the actual pew-pewing, according to her attorney, was not caught on camera. This is what the attorney is saying. So if she's saying that the actual pew-pewing was not caught on camera, I'm wondering how she plans on proving that before the pew-pewing that Ms. Johnson was confronted aggressively. Because you have to remember that in order for this self-defense case to work, she would have had to pew-pew her in the actual act of her being attacked or her pew-pewing her. So if her motion is contradictory. If you're saying that there's no video of the actual pew-pewing in order to defend your client, then how are you going to prove that she was being accosted in an aggressive manner, causing Romeca to be pew-pewed? It's either one or the other. So if you don't have the proof, and well, if they don't have the proof, you don't have the proof either. See what I'm saying? So she's saying that Ms. Johnson was confronted aggressively, but then she's also saying that there's no actual footage of the pew-pewing as well. She goes on to say, now I'm getting back to reading, neither was this a twisted sense of self-defense. Ms. Johnson and her 6-month-old child were in harm's way September 8th. Ms. Johnson should not be punished for being legally permitted to carry a firearm for her protection and using it accordingly. Let me stop again. She also going to have to explain to the court why she felt it necessary to pew-pew her so many times. Let me continue. Neither did Ms. Johnson fire multiple times at her with a pause between. So she's saying that never happened. Okay. And the first shot and the subsequent shots as alleged by the state. It's interesting that she says that because how does she know that if there's no footage of the shooting? This is what I would ask as the prosecution. Miss Ari Williams, you're saying that there was no subsequent pause in between the pew-pewings as the witnesses have reported. But then you also said that there is no footage of the pew-pewing. So if there's no footage of the pew-pewing, how are you confident that there was no pause in between the pew-pew? How are you, a person that was assigned to this case, not assigned, but yeah, well, they took on this case, you verify that there was no pause in between the pew pew when you just stated in this motion that there's no footage of the actual occurrence of Miss Meeks being pew pewed? It's either one or the other. So Quadacia's word to her attorney is not going to fly. Quadacia is the accused. So because Quadacia went to Ari Williams and said, I did not pause in between shots, that's not enough to release you. That's not enough. Of course she's saying that. She's the shooter. Of course she's going to say that. She is the shooter. Okay, so let's go. Where did I leave off at? Rather, it is alleged that there were 3 pew pews in the beginning and 2 shot afterwards, with 10 seconds in between each shot. Let me read that over again. She said, instead of what the victims are saying, that there was a pause in between the first shot, Ari is saying, rather, it is alleged that there was 3 shots in the beginning and 2 shots afterwards, with 10 seconds in between each shot. Again, this proves that the incident that took place on September 8th was not done as a result of Ms. Johnson's character for violence, but out of need for protection of self-preservation. Ms. Johnson is a mother of 1 and is also currently pregnant with her 2nd child. Ms. Johnson was about to begin dental school. Prior to that, Ms. Johnson had a successful lash business. She is not someone who is at risk of repeating this offense against any of the witnesses, nor the community at large. Ms. Johnson is known to be a loving mother and devoted daughter who has contributed tremendously, not only to her household and family unit, but to her community, having donated food and supplies to shelters for women and children, while also volunteering at homeless shelters. She is known as being an anchor within the Johnson family, an asset in her family and within the community. I'm just laughing because, okay. Ms. Johnson is grounded in her family values, driven by generosity, compassion, and willingness to serve others. It seemed to me like the only thing she's willing to serve is bullets, baby. But let's go ahead and continue to read on her. But this is what her attorney is supposed to do. Her attorney doing her job. This is what your attorney is supposed to do. Your attorney is supposed to defend you by any means necessary. So she already just doing her job. On her PSA, Ms. Johnson scored a 2. Now, you guys remember, I just went over the scale of her detention scale, basically saying she's only reached a 2, and that's because she hasn't had any other violent offenses. On her PSA, Ms. Johnson scored a 2. And let me just say before I keep reading, this is not going to work. And I'm going to tell you why. Anytime you're charged with this is not a motion to dismiss her charges. This is a motion to get her released from detention pending trial. I'm going to say this is not going to work simply because historically, once you're charged with first-degree murder, they're not letting you out in Illinois. That just is what it is. You know, I give it to her for trying, but in Illinois, baby, when you charge with first-degree murder, they're not letting you out. Historically, they just are not. They just not. But hey, get paid, baby. Get paid. When I say get paid, I'm talking about Ari. Okay, so let me read this over. On her PSA, Ms. Johnson scored a 2 on the criminal activity scale, a 2 on the failure to appear scale, and her PSA score coincided with level 3. Ms. Johnson is not a threat to the safety of any persons or the community, and the state will not be able to show by clear and convincing evidence that Ms. Johnson poses a threat to the safety to any person or persons based on the article facts of this case. Number 4. This court cannot determine based on the evidence presented that Quadacia Johnson is at risk of failing to appear at future court dates, and that no combination of conditions can mitigate Quadacia Johnson's willful flight. A court may only deny pretrial release if the defendant fulfills one of 6 categories of offenses and meets the corresponding standard of threat to the complainant and has a high likelihood of willful flight to avoid prosecution. For the reasons already articulated of this motion, Ms. Johnson is not at risk of fleeing from future court hearings or engaging in future criminal activity. Ms. Johnson has appeared at every court date set by this court. I mean, Ari, now I got to stop you right there, Ms. Williams, because of course she came to every court date. She's incarcerated. She said Ms. Johnson has appeared at every court date set by this court and will continue to appear for every court date to ensure she can care for her family and her own livelihood. Another thing that, let me stop reading right here and do some commentary really quick. Another thing that's going to be taken into consideration is that Miss Johnson is relying very heavily on Quadeja being released because of her child and because she's a mother and she needs to be released in order to take care of her children. But the thing that I think that really should be asked is, well, will she be taking care of her children? Because one of her children is now a ward of the state. She's not even expected to take care of that child legally. Legally, that child is not even in her custody. Legally, her child who's already been born, the baby, is in the care of a family member according to DCFS. So I'm sure they're going to argue, well, Miss Johnson doesn't need to be released to care for any children because DCFS has taken temporary custody of her child. What's the baby name? Carson has taken temporary custody of the child, and the child is now in care of a family member. So Miss Johnson has no reason to be released to care for the child. The state of Illinois gives a board payment to the foster parent, being her family member, to care for the child. So the state of Illinois is aiding in the care of the baby. So she doesn't need to be released to care for the child because the child has been taken by the state of Illinois. Moving on, Ms. Johnson has appeared. I read that the circumstances surrounding Ms. Johnson's case do not indicate that Ms. Johnson will fail to appear for future court dates. In arguing that no combination of conditions could mitigate Ms. Johnson's willful flight, the state must rely on more than the facts of the case and the charge itself. She then inserts the case People versus Stock as a reference. Furthermore, the nature and the circumstances of the charged offenses is just one factor to consider in determining whether the threat posed can be mitigated by conditions of release. And she also enters another court case for reference, People versus Lopez. On this prong, the state bases that there are no conditions that can mitigate the risk that Ms. Johnson poses where electronic monitoring is not designed to monitor people charged with violent offenses like murder. Such basis is generalized, not individualized, to Ms. Johnson and her personal eligibility or possibility for compliance with the conditions of electronic monitoring. Additionally, there have been instances where defendants charged with unaliving have been granted pretrial release where those defendants were not considered dangerous. So she then goes on to insert another case as a reference where someone was released in 2004 where this defendant was charged with first-degree murder after he punched the victim with his bare fist. Okay. It was determined eligible for pretrial release. The funny part about that is not funny, but the fact that she inserted that particular case in there, I don't think that it is relatable at all to the actual case, because the case that she inserted, People versus Miller, is a case where the defendant did unalive someone, but he unalived them during a fight. He literally unalived the person while they were fighting. So that's a lot different than alleged argument in shooting your weapon 3 times in self-proclaimed so-called self-defense. So People versus Miller is clearly not the same as People versus Johnson, baby. Johnson did not unalive somebody in the middle of a fight. Hold on one second. Okay, let's get where did I leave? People versus Miller. Okay. And then she also asserts People versus Smith 2004 in Illinois Appellate Court, where the defendant was charged with first-degree murder, armed robbery, home invasion, and theft. The state was unable to cite any reason outside of the charge itself to justify detention, so the court found that the defendant was not a threat to the community and was released from pretrial detention. The only thing that's missing from a lot of these different cases are witnesses. And this is just my opinion, obviously. I just don't think that I think that the court, not only as they stated on previous paperwork, are they trying to protect the community, but they're also concerned for the witness safety. And that's completely understandable. Similarly, People versus McDonald emphasized mitigating factors for a defendant accused of murder when concluding that the trial court's findings of whether no condition of combination of conditions could mitigate the defendant's threat was against the manifest weight of evidence. People versus McDonald, who has no criminal background, who has been continuously employed since graduating high school, who was working a security job at the time of the offense, who lives next door to now she's talking about a different case here. His mother and brother, who served as a church deacon. He has no other children. 3 years earlier, the trial court found defendant sufficiently safe for release on bond with conditions. Okay, so now she gets into Johnson's character. Similarly, Miss Johnson is a 31-year-old mother with no background of violent criminal history. In the McDonald case, has been continuously employed up to the date of her arrest, December of 2025. She has given back to her community. Ms. Johnson has also given a level 3 in her PSA score, where detention was not recommended by pretrial in this new system, where a relevant consideration in determining if conditions are viable is whether there is a reason to believe the defendant is likely to violate the conditions the court might impose. Ms. Johnson has not given the court any reasons to believe that she would fail to comply with any of the conditions imposed on her if granted release. They then cite a case, People versus Farah. Simply because a person is charged with a detainable offense or poses a threat to public safety is insufficient standing alone to order detention. So she's saying just because my client is a threat to public safety, that don't mean that she shouldn't be law. Okay, let's go continue reading further. Simply believing that Ms. Johnson would be incapable of complying with electronic monitoring and referencing the way that electronic monitoring is set up, finding that there were theoretically possible ways in which pretrial supervision might fall short of clear, convincing evidence that no conditions can mitigate the threat. Additionally, the state has failed to provide any evidence that Ms. Johnson either resisted arrest, attempted to evade prosecution, or had any history of missing court hearings. The state cannot argue or present any history of attempts by Ms. Johnson to evade prosecution, nor has the state acknowledged any of the potential mitigating factors listed in Section 110-10. The state is simply making allegations and proffers about the facts that the case and the defendant's criminal background. Ms. Johnson has no other violent criminal history beyond the current case, and the record before us demonstrates that she has otherwise been an upstanding, listen to this, y'all. Ms. Johnson has been otherwise an upstanding and law-abiding member of the community. If the court still had concerns about Ms. Johnson appearing for future court dates or engaging in criminal activity, Ms. Johnson could be placed on home supervision or electronic monitoring. She's trying to get her up out of there. She's trying to get her up out. It ain't gonna work, but she's trying. Ms. Johnson could be placed on home supervision or electronic monitoring. Placing Ms. Johnson on electronic monitoring or home detention would allow the court to inspect, direct, and evaluate Ms. Johnson's compliance with terms on her bond conditions. See Williams versus Cook County. Wherefore, defendant Cordasia Johnson respectfully requests that this honorable court vacate its order for pretrial detention. Woo, that was a lot. And then attached to this, let me go ahead and pull. Okay, so attached to that, she basically has, her documentation, which she feels would assist her with her argument. I'm trying to read it sideways. Okay, so she had, okay, no, this is the motion. Okay, so, okay, enter December 23rd. Order this matter coming before, okay. People versus the state of Illinois versus Quadesia. Order this matter coming before the court, and the court being fully advised in the premises, it is hereby ordered that Quadesia remain in custody. The next court date is January 7, 2026. The assignment, defendant in custody, transferred to the criminal division PJRM 101, CO1, superseded by direct indictment. Okay. Yeah. This was entered December 28th of this year. People versus Quadesia. Order this cause coming before the court being fully apprised in the premises, the premises, and having jurisdiction of the subject matter. The court finds that the defendant was indicted for the offense of first-degree murder under the case of, and it has the case, pursuant, has the code here, Cook County Department of Corrections inmate number present here shall submit a mandated DNA specimen being obtained from them by the Illinois State Police. The Cook County Department of Corrections shall make the defendant available to personnel from the Illinois State Police only for the purpose of obtaining the requisite buccal swabs and fingerprint in the Illinois State Police DNA indexing database buccal swab collection kit pursuant to the Administrative Code Title 20, Chapter 2, Part 1285, Section 1285.50. The defendant shall be returned to the custody of the Cook County Department of Corrections immediately after said collection kit is obtained by the Illinois State personnel. The end. All right, let's talk about it. So let me go back to my comments, y'all. All right. Let's see what y'all down here saying. Is that what that said up? Well, it did state that on the paperwork. We know Quadasia's been indicted. I don't know what people are talking about. I've been saying this for the longest. So I don't know, Ebony. I don't know. I had that argument on Friday. I am not arguing with folks anymore. The young lady has been indicted. But let's move on. Do they know Ari personally? I don't know. Ebony says, so she put her own child in danger and they want us to believe that she wouldn't harm the public. That's what they're saying. That is the argument. And also, that is, from what I believe, is going to be the argument. Ebony said it's normal for them to take DNA. That's a part of the process. That's a part of the process before being incarcerated. Not even necessarily, incarcerated. They take a DNA sample and fingerprints, and it's entered into the system, like it said. Didn't she say online that sometimes you just gotta pow a bitch? Yeah, she did. They're trying to say that wasn't her, but all of that is gonna come out if this case goes to trial. And then I also believe that the attorney, correct me if I'm wrong. Well, I'm not going to say that, but this is what I think. I think that the attorney, depending on whether or not what she believes Quadesia will be released, I'm pretty sure that Quadesia is not going to be released. I'm almost 100% sure they're not going to release her. However, I think that she's waiting to put that motion in. However, the court decides to handle Quadesia is what the attorney is going to base what she's going to want to do moving forward off of that. For instance, if they say release her until trial, then they won't take a plea. But I definitely think, okay, they're going to try to see if they can take a plea if she is not released, because she doesn't want to sit in jail. However, like I told y'all the other day, it's not just up to Quadesia to take the plea. I'm pretty sure that they would have to present the time offered in the plea to the family as well. And the family is also probably going to have to agree to whatever plea whatever plea is presented for Quadesia. The family also is going to have to agree that that would suffice. I personally don't see the family doing that, but we'll see. Holly has a single black female syndrome for real. I'm gonna go up a little bit, then I'm gonna come down. I want to see what y'all were saying earlier too. State pull out phone records now on this ghetto State pull out phone records right now on this ghetto fabulous lawyer. I seen her cases, none deal with murder, but two, little boy and his mom Mallory advocated for him, and then mom dropped Ari regarding money. Holly is safer in jail. The judge not reading not the judge not reading all of that. I need Ari to stop mixing whatever it is in her coffee. She sounds like a relative of Holly. No, I personally don't think she's her relative. I think she's just her attorney. Attorney, let me just explain something to y'all. An attorney is going to do their job. Jeffrey Dahmer had an attorney. Okay. Serial killers have attorneys. And somehow they have to defend their client. So when you listen to an attorney, you're like, oh yeah, how are you what are you talking about? This person is, it's their job, especially a defense attorney. They have to defend a person who is being accused. So to us, it sounds like bullshit, but at the end of the day, they have to, like I said, they're going to do and say what they need to do and say to defend that person. Like I said, everybody has to go through due process. Everybody is afforded an attorney. Hold on one second, John. Okay, I'm back, y'all. Let me get back to the comments. Sherry Blossom says she didn't care about her own child on September 8th. She left her child unattended in the vehicle. Carlos and Quadesia show no concern for that baby. Let's go down. Let me see. Discovery will be presented January 7th as well. Meaning, thank you, Sherry. Meaning that not only is this motion going to be presented January 7th, but also discovery is going to be presented January 7th. Meaning that the prosecution will be showing their evidence or beginning to show their evidence. May she spend the rest of her days in prison? Philly Girl says yes, but that's up to the state. A plea is a privilege. True. That's true. Ari is trying. Why isn't this working? Is it working? Okay. Ari is trying to deny footage of the gun scene, but forensic science shows the evidence that that's why the state needed DNA on Holly for the weapon. Ebony says, so it's not what some of us were thinking. They said it's normal for them to ask for DNA. True. Yeah. Yep. So let me see if I can pull it up again. Do y'all want me to pull that up again or no? I'm sure y'all screenshot it or whatever. Well, let me pull it up again. Hold on. Just the DNA order. Let's see. Give it a second to pull up. I had to open up another screen. Let me go back to so we're gonna wait on, let me Wait till it loads again. Maybe I shouldn't have clicked out of it. Let's see. Okay, so DNA order. So let me just show this again just to bring some clarity. So here's the DNA order here. Okay, and just to read it again. And y'all be careful what you guys are saying in the chat. I don't know why, but I'm seeing that some people's messages are being restricted. I guess YouTube does that. So the order says this is coming before the court being fully appraised in the premises and having jurisdiction of the subject matter. The court finds that the defendant was indicted for the offense of first-degree murder under the case number, and it has her case number here, pursuant Cook County Department of Corrections inmate number here, shall submit a mandated DNA specimen being obtained from them by the Illinois State Police. The Cook County Department of Corrections shall make the defendant available to personnel from the Illinois State Police only for the purpose of obtaining requisite buccal swabs and fingerprints in the Illinois State Police DNA indexing database buccal swab collection kit pursuant to Administrative Code Title 20, Chapter 2. The defendant shall be returned to the custody of the Cook County Department of Corrections immediately after said collection kit is obtained by Illinois State personnel. So this is actually what I was saying on my previous live stream. I did hear a lot of people, or I heard some commentary, basically saying that the DNA was being obtained to place other DNA on the weapon or whatever the case is. But I did do a previous live stream where I kind of told you guys that a collection of DNA does go along with an indictment. So once there's been an indictment, it's pretty much procedure to collect the DNA. So that's what I would say. But TLC is saying that that's not true. I don't know. The Mexican said Carlos shot her. They both shot that pistol. The prosecutor gonna eat Ari ass up. Oh my goodness. Okay, so let me pull this down. I guess I'll keep it up just in case for reference. Let me go down. I don't know. Free, what's going on, boo? She's taking DNA not to prove she shot her. We know she shot her and stated that DNA is a strategy used by the defense attorney to change the narrative. Cindy said Holly Scary will be arraigned on 1/7/2025. No, she's not going nowhere. Miriam said, but Ari is trying. I give her credit, but this case knows her client Holly is wrong as hell. Philly says, Karan, that's false. You can be indecent and released. April said, question is the next court appearance is for her to put in the plea. Next court appearance is for discovery to be presented. It is for this motion to be presented for her to her attorney to fight for her release. Larissa says supposedly Carlos knows that attorney is from the community where I live at, which is Inglewood community. It's possible. It's possible. Mm-hmm. Tonya says, so no witness knew what they saw and heard except Carlos and Ari. No, except Carlos and Ari knows what happened for sure when there's no footage per her. Okay, got it. Can I get a refund, please? I mean, this is what I'm saying about her motion, per her own motion, that there isn't any footage of the actual pew-pewing. That's what she's saying. So no bail, how to keep her ass locked up. It's too late. Texas got a swab on the way in. Prison systems here on swole. Holly unhinged. Demons gonna run rampant. Protect the Romeca family. We here. She from the hood. Oh, she's from Inglewood. That would be a conflict of interest. So I don't know if he knows the attorney or not. If he does, I think that that would be a conflict of interest. Hey, Madus, I came in late, but you did say that the info you read is supposed to be what's given to the judge in January. Yeah, it's the motion. It's the public motion that will be presented in January. Maya Brown says in court, Ari acted like she didn't even want to take the case no more after defense chewed the ass. uh, let me go down. Judge will read it all, but good thing he has children, attorneys, lie, steal, and know the state workers. Also, state going for 60. Burke is getting killers off the street. I understand the lawyer's motion. Neil, she took it because it's a big case and for more exposure, in my opinion. My real name's Justice for me. Okay, welcome in. Ari is saying what Gary Coleman told her to say. Holiday Queen said all clients ain't good. Ari gonna have demons on her. Get your bag though, I guess. Heavy on big guy. I agree with that. Well, you guys, I came, I saw, I conquered. I read the documentation, and I'm getting ready to go ahead and log off of here. I've been on over 2 hours. That's not typical of me. I'm gonna read a few more comments, and then I'm gonna go ahead and dip out. And y'all can do what y'all want to do with that information. Maya Brown said, well, did she put a motion in for HIPAA? Can you explain that so I can understand? I didn't see a motion for HIPAA. How could she file a motion for HIPAA regarding her pregnancy when the attorney is the one that brought the pregnancy to the table at the court date? She's the one that mentioned the pregnancy. That was one of her arguments as to why she should be released initially. So I don't see how that would work. Thank you, Lysandra, for that $10 super chat. Super sticker. I appreciate you, boo. Well, let me see. Well, she did put motion in for HIPAA. Can you explain that so I can understand? I don't know. Her attorney is said to be a friend. I don't know that either. That hoe is slow and less money pool. Our Mason. Thank you, Upper. Enjoy your evening. Thank you for your information and time. No problem. I'm about to go ahead and log off, y'all. I appreciate y'all for joining me tonight. Hopefully, I shed some light on some things as far as to what's going to happen in the future court date, and what the defense probably will be saying if this case does go to court, and so on and so forth. So thank you for watching me. Hit that like button. Make sure you hit the notification bell so that you're notified the next time I live stream and the next time that I do post content. Make sure that you're subscribed to my channel if you're here and you're in the bushes. Go ahead and subscribe to me. I do my best to provide quality content, so I'm not going to disappoint in future live streams. So go ahead and subscribe to my channel. I also have another channel. If you go to your search bar and type in Upper to You, I'm not that active on that channel, but I do have another channel if you want to subscribe to that one. Once I end this live, please make sure that y'all go ahead and hit the hype button for me to push me further out into the algorithm. I want to say again, thank you to everybody that joined and that helped me to reach my goal today. I appreciate you. For those of you guys who were unable to donate to my channel monetarily, I appreciate you as well for hitting the like button, giving me a view, and engaging in the chat. All right, y'all. Thanks again. Good night. Peace.
I got a lady. Hey, name is the upper echelon, she a debater, baby. She can give it to you straight, no chaser. She got the smarts. She got the heart. She got the heart. She got the confidence. Baby, she the upper echelon. You know you intimidated. Stupid can't play with smart. She got the smart.